I mean, I've had many of them. I mean, I'll name one in a minute, but one thing I would say about them is that out of all the sex offense cases I've handled, I would say half of them never went to court, meaning there was an allegation, you had a client, there was an investigation done or something, and it turned out that they weren't prosecuted. And that's really quite often not because of me, it's because of the facts, of the evidence of the actual case that it happened. I represented a guy who was accused of a serial number of sex offenses, and this was back before the new law about this, but he was tracked with GPS tracking without a warrant. And that was the first time in Virginia this had come up in a case of this magnitude. So I raised it in the circuit court and ended up appealing that through the Virginia Supreme Court, because at that time there were no rules about whether the government could track someone with GPS tracking without a warrant. And while that case, so that was really interesting because we got to be the first people in Virginia raising that question. Before we got done with our case, Jones v. United States went to the U.S. Supreme Court, where the U.S. Supreme Court held that indeed it does require a warrant to track someone with GPS because it's a seizure to attach a tracking device, let's say, to a car. So we didn't, that affected our case, but it wasn't because we got to go to the Supreme Court because that other case went there first. But that was really interesting because the evidence in that case of guilt was overwhelming. There was no reasonable way to deny that. But the issue was about the Fourth Amendment and, whether the government should be allowed without a warrant to have that level of intrusion into people's lives. And it turns out the answer to that, because of the case I just named and also cases that have followed that, is tracking with cell phones or other methods these days require a warrant.